TV Ghana. In this segment, we are talking democracy and judicial matters. And the past few days, Ghana's democracy has faced renewed scrutiny amid claims of free speech criminalization and direct attacks on the judiciary. If you recall, the minority leader in parliament, the Honorable Alexander Afenyo-Markin, publicly criticized the judge handling the case involving some NPP figures, including the remand of the Bono regional chairman of the NPP, Kwame Bafo, a.k.a. Abronye DC, etc. Now, he labeled the judge as NDC aligned, and he vowed to continue disrespecting him until he does the right thing. This prompted Government Communications Minister, Mr. Felix Kwakye Ofosu, to accuse the Ghana Bar Association of what he called political bias and also selective silence, contrasting it with its past reactions to criticisms from other sides. These incidents occur against the backdrop of recent arrests and prosecutions over social media posts and also public comments, raising fears among sections of the public of a chilling effect on expression, erosion of judicial independence, and also politicization of institutions. This morning, we are joined by a retired appeals court judge, Justice Isaac Delali Duse. He will lend his expertise to our conversation to explore whether Ghana's democracy is at a crossroads, and will look at the balance between criticism and what it should. I'm sure they appreciate it. I want us to touch on the substantive issue here, which is the case involving the gentleman popularly known as Abronye DC. He is facing charges of some misdemeanor offenses. So, in your experience, would a misdemeanor offense warrant a denial of bail, or would it warrant a remand into BNI custody?
Under normal circumstances, a remand would normally be into prison custody. You don't remand somebody even into police custody unless there's a special reason for remanding the person into police custody. Once the person comes to court, he leaves the environment of the security organizations and joins the normal custody system. BNI and others typically have to deal with committed a political crime by publishing what he has published is an issue which has to be determined by a court. Normally, a misdemeanor is the smallest offense in this country, and it should not be treated with high handedness. But perhaps there are some certain circumstances surrounding it which has not been made public, which is giving the judge the impression that it has been treated with.
Okay, so
the high-handedness, that's...
And it's one of the arguments the NPP makes, that they've not seen a signed remand warrant, and that makes his continued detention unconstitutional. What do you make of that?
Oh, the announcement of the remand in open court
is a warrant.
It's a warrant by itself. You don't need to go to the extent of issuing the warrant. That warrant is supposed to be issued by the registrar. So if the warrant hasn't come out yet, that is a delay or a default. But it doesn't detract from the fact that the person has been remanded into custody.
So where does a person, whether he's a seasoned lawyer of many years and a politician and a member of parliament and a leader of a side of the House, register his displeasure with a judge's discretion? Where should that have been posited?
Well, there is a little, or may I say, a very uncomfortable understanding or misunderstanding of democracy in our system.
Uncomfortable misunderstanding?
Yes, uncomfortable because No rights are absolute. Every right under the Constitution has a limit. And free speech must not be violent speech. Free speech will be speech given with decorum. There's the minority leader who have made all the points he wants to make without using violent language. Because violent language has given the world a lot of problems. Violent language was what caused the problems in Rwanda. So as much as possible, even if you have a right, sometimes the way you approach it detracts from the rights that you are exercising. Yeah, I'm particularly not happy about the words that he...
And some of them included, I have no respect for him. I will continue to disrespect him until he upholds the law. How is that unconstitutional, and how is that him not expressing himself and what he's feeling?
The respect that he has, the respect will be shown by appealing against his judgment. The judgment, that is the use of discretion, which he thinks was wrong. But to go out there and, I don't want to use this to rough him up. In public, it's not the best. And what pains me some of the times is the way we tend to label judges as either NPP or NDC.
How dangerous is it for a figure like the Honorable Minority Leader, and not just in this case, but in times past, how dangerous is it to label a judge as political party aligned or affiliated?
It is dangerous because every judge is appointed at a time when one political party is in power or the other. Now, for me, merely being appointed during the regime of one political party should not necessarily label you as NPP or NDC. Your output will determine for you where you actually lie. And judges, like human beings, can make mistakes. And when they make mistakes, there are legal provisions and procedures for correcting those mistakes. This is a circuit court judge. You can appeal to the Court of Appeal. You can appeal to the Supreme Court. You can, if you are not satisfied, you can go for a review. There are so many other avenues above that you can approach. But when violent words are used in criticizing a judge, it might lead some misguided people to attack the judge. You never know how people will understand your violent reaction to certain things.
The NPP side argues that judges should not be above condemnation if any conduct of theirs is deemed as such, and that appearing to shield them from that amounts to some kind of attempt to silence people's speech.
There is a difference between condemnation and criticism. Condemnation is a violent word. Criticism is a civil word. You can say everything you want to say when you are criticizing somebody without using violent words. But once violent words begin to come out of your mouth, then you have gone beyond criticism and you are now in condemnation. Condemnation is not the appropriate way to treat a judge when he faults.
Even when public frustration or personal frustration has come to play, as we saw in the case of the Minority Leader.
You see, the word discipline applies to everybody. But even in your house, if you are not properly, I don't want to say, if you are not properly careful about how you use words when you disagree, you might find yourself being blamed for how you reacted when you are angry.
Where should we draw the line between what should be legitimate scrutiny and then, wading into undermining the power of the court?
This one is not quite undermining the power of the court. Rightly, if what the judge did was beyond or a wrong use of his discretion, the reaction, from my mind and my humble opinion, is overboard. Because as a leader of the minority in parliament, the leader is a very powerful individual. He has a lot of following. And as a leader, you must not easily descend to the gutter to fight.
Does that suggest that if a senior political figure is allowed to do that, regular members of the Ghanaian public can think it is okay to do same?
Is that your follow your leader?
Okay. Does it worry you that the judicial space has become, very vulnerable to these commentaries beyond the political space? Do you think it's safe? Do you think it's healthy for our democracy?
Sometimes it's a malaise which needs to be corrected. Because as I said earlier on, people misunderstand free speech to mean that anything goes. But for every freedom that you have, on the other side, you have a responsibility. Freedom without responsibility is dangerous. That is why I said that criticism is different from condemnation. Condemnation at a certain level should not be the word to use. Criticism, for criticism, every judge can be criticized. Everybody knows that judges are not gods. But everybody knows that the judge is the alter ego of the judicial system, particularly with reference to the case before him. And when leaders like the minority leader post themselves the way he has done, I think he should think of retracting some of the things that he said. Some of the things.
But not all.
He is right in some of the things that he said, but he is also wrong in some of the things that he said, particularly the use of intemperate language and whether he actually qualified from the law school. And, it is a little too much for lack of better words, street talk. And lawyers are not supposed to use street talk when they are talking in their professional
Okay, so
capacity.
when he says he prays that the judge will summon him for contempt and that he will continue to disrespect him, do you think that he should withdraw that bit, or?
That is a challenge that he has thrown. Mm-hmm. I'm not worried about that one. What I'm worried about is the fact that he even questions whether he passed the bar exam before he was appointed. That goes deeper into the processes of appointing judges. Did the judicial service not do proper due diligence before appointing him to the bench? If he didn't pass his law exam, that statement is a little bit of an extreme, and I think that if he withdraws that, it will put him in a better stand.
Okay. Now, there's been hard pushback following the Honorable Afenyo-Markin's comments, and government spokesperson, the Honorable Felix Kwakye Ofosu, has also been very vocal, calling on the GBA to act. It's saying that the GBA has not rebuked the Honorable Afenyo-Markin at the time for the comments that he made. He accused the GBA of remaining silent because the Honorable Afenyo-Markin is an NPP lawyer, and said that if he had, the GBA is not an NPP grouping. What are your thoughts on the Honorable Felix Kwakye Ofosu's comments first and foremost, and then the GBA's later reaction to the comments made by the minority leader?
Well, Kwakye's statement is an observation.
Observation,
yes.
Okay. So we have a criticism versus a condemnation, and now we are having an observation.
Yes.
Okay. Is he right to make those pronouncements?
Well, I don't know the basis from which he made that observation.
From the Honorable Afenyo-Markin's comments on the issue.
Yeah. Honorable Afenyo-Markin's remarks also have a problem with remarks. I don't know the basis on which he's assuming that the judge is an NDC judge. Equally, I don't know the basis on which Felix Ofosu Kwakye says that the bar.
He says that the association responds quickly when non-NPP figures make controversial remarks.
Well, I haven't observed that very clearly, so I cannot comment on that.
Okay.
Yeah, but he's entitled to his observation.
And you think that he has
and his observation is observation of a group to which I don't belong.
You don't think the GBA is an NPP grouping, or is shielding persons within the NPP or affiliated to the NPP who make certain remarks that could have been criticized by the same institution if someone else had made it?
Are there any examples? Has he cited any examples?
Well, the Honorable Felix Kwakye Ofosu said in the past they had been very vocal about other comments that others have made. But I just want to pick your thoughts on whether the government minister's accusation of bias risks putting the GBA in any light, looking at the political implications, if that's less stakes on the association.
It's very difficult at the moment to come to any conclusion on that matter, because the basis of those observations are not known to me. Yes. If you can give me the basis of any specifics.
I'll find the video so that we air that out for you. But what the government spokesperson has said is that he has long dismissed the Ghana Bar Association as an NPP grouping. And his words, if it were not so, the intolerable abuse of this judge by the minority leader would have elicited an immediate and compromising response. And like I've said before, he says the association responds quickly when non-NPP figures make controversial remarks, but appears silent because the offender this time was one of their own. So those are some of the comments that he made.
I'm not aware of the time lapse between the comments of Afenyo-Markin and the comments of the government spokesperson. The Ghana Bar Association, as I know it, is an organization comprising of...
Honorable Afenyo-Markin made the comments on Sunday, yes. And Honorable Felix Kwakye Ofosu made his comments on Sunday. Yeah. So the day after Honorable Afenyo-Markin's comments.
Saturday and Sunday.
Sunday and Monday.
Sunday and Monday. You know, the Bar Association, as I used to know it, will not allow anybody on his own to go about making a statement on this behalf unless at least the executive committee of the bar meets to take a decision on the issue. So I think that the time lapse between the statement of the Honorable Afenyo-Markin and Honorable Kwakye is a little too short.
Okay. But the GBA, who appeared on City FM's Eyewitness News on Monday, insisted that we are not a wing of the NPP. He said the matter had only recently come to the GBA's attention and the association was already preparing to make a statement, and people were too quick to conclude that the GBA would stay silent. So he argued that delay did not equal bias, and that due institutional process had been followed before issuing, had to be followed before issuing a formal statement. Do you think that's what it should have been?
That's what I just said. That you be at that same hearing.
Okay, so
this is what some people describe. The kind of thing he did is some of the things that people describe as vulgar abuse.
Okay.
In vulgar abuse, you don't really mean what you are saying, but you are just saying it so that the person will feel embarrassed or feel pained. It might not have truth in it.
Would an apology suffice?
Apology is a balm for every wrong done.
But not the cure?
No. But to a large extent, it might end up in the cure. Because when somebody offends you and he comes and apologizes to you in the same way in which he did it, then you feel comfortable.
What would the appeal process have looked like if one person decides to go down the appeals route, and you have several years of experience on the appeals court?
The appeals process is very fast and very short. All you need to do is to file an application before the next higher court for bail. And it shouldn't take more than 3 days.
Okay. That quick?
Yes. It shouldn't take more than 3 days. Once you have the order of the court, you file the appropriate application for bail at the higher court, and within a very short time. The hearing doesn't take much time, particularly in the view of the fact that the offense itself, even though it is very emotionally painful, is only a misdemeanor.
A misdemeanor, and I'll go back to Abronye's case substantially, because the argument by some of the NPP supporters is that this is a clear misdemeanor case that has been escalated to the level it has now only because the personality involved is a known NPP, supporter or leader, and that the Mahama administration is using these instances to silence its political opponents. Do you agree?
It's a viewpoint that they are espousing. But the question is whether the person has committed the offense or not. And the offense has no political color. It doesn't matter who you are. Anybody else could have said the same thing that Abronye said, whether he's a politician or not. Any public commentator can say anything that. So the fact that it was Abronye was the regional chairman of NPP doesn't mean that he was even speaking on behalf of NPP. Does
it bother you that it appears, to some at least, that the NDC and the NPP and political figures seem to back or unback the judiciary depending on whether or not they are in power or opposition and who is involved? And how risky is that?
Choosing where to lean is always a right which everybody has. And it bothers me if the choice bothers some other people, because all of us have different points of view. The law about the contempt is enshrined in the Constitution. And constitutional provision as Article 126. And that is the ground norm, the root of all our laws in this country. So you can't easily toy with that law and its consequences, because it's a constitutional right that is in the law. But then again, when you act in a way that draws criticism, you must face the criticism.
And how do judges maintain that constitutional impartiality and, treat everybody with the fairness that the opposition requires them to? You've had so many years of experience doing that.
The first thing is your body language. The body language, I know you can read body language. Women are very good at reading body language. The first thing that that should strike anybody when they appear before the court is the body language of the judge or the judges. Everybody reads it. Then the next thing, so you must avoid exhibiting body language that shows, hatred or dislike or anything towards a person who is appearing before you, whether it's the person himself or his counsel. You must avoid doing anything to show that you dislike the person or you hate the person or that kind of thing. Then the second one is the language you use can also easily expose your bias.
So the spoken language, beyond the body language, there's also what you say.
That's right. That is why, as a judge, you must be as cool as possible, as if you have no temper, as if you cannot get angry. So that comes as a cliche which says that the person is as cool as a judge.
Oh, as cool as a cucumber, but okay.
As cool
as a judge.
Yes, as cool as a
good
judge.
One.
Yes.
What can all the players in this matter, from the Honorable Minority Leader to government spokesperson to the accused person himself, Abronia, and the other NPP figures who are currently facing different courts for different matters, do to ensure that that respect for the judiciary is still maintained? And where do we go from here?
Respect is a two-way street. It's not a one-way street. You respect me, I respect you. Now, there should be reasons why you respect or disrespect. And the reason may be right or wrong. So everything depends on what other people perceive. But I think that the extent of extreme partisanship in our politics is one of the reasons why all these things are coming on. And it can be cured if we have a way to take away the winner takes all situation that we have in this country. Because once we are the winner, it means that we are overwhelming power over everybody and nobody else can do anything about it. And then the
vanquish of power is for constitutionalized. So shouldn't that be some kind of check?
Yeah, but where you have a winner takes all, the balance becomes a little difficult to maintain. That is what's happening in the U.S. The president in the U.S. currently sees his powers as overwhelming, and he's riding roughshod over everybody. House of Representatives, Senate, and everybody is doing what he likes.
Can we cure extreme partisanship?
Extreme partisanship can only be cured when there is fairness in the allocation of responsibilities. What I mean is that people have been calling for elections into the district assemblies. And these assemblies are very fundamental in the management of the politics of this country. I dare say that if district chief executives are elected, the chances are that the minority may not be the extreme minority that it appears to be today, which are the reasons why they are very anxious. Because you will find a sizable number of district chief executives belonging to the minority party. And for that matter, the hunger for power will diminish. Right now, I can say that without equivocation, that the minority is very hungry for power. And some of the things they are doing exhibits that hunger.
So let's go back to, and the MMDCEs have just spent a year in office since the appointment by His Excellency the President last year. Yesterday on our current affairs program, Public Concern, we listened to some of what they've done in the past year, and you can catch a repeat of that later on GTV. Let's go back to talking about the reforms. You say that there are certain things that a judge on its own can do, and the political class have to avoid extreme partisanship. What more needs to be done? What should we see changing?
There is a need to make sure that, if possible, when some appointments are made, there should be a reason why they are made, so people don't complain about how the appointments are made.
Are you referring to the MMDC situation again?
No, not the MMDC. All appointments, appointment to SOEs, appointment to ministerial positions, appointments to judicial positions, and all those kind of things. Once a person gets appointed and people dispute his qualification to be there, then there's a problem, like we have with Afenya-Markin and this current circuit court judge.
How can we ensure that we protect free speech whilst also protecting judicial independence? Because that's the crux of the matter before us today.
As I said, free speech is not a license to misbehave or to insult. In our local languages, there is barely a difference between a quarrel and arguments. And I think some of the problems we have in this country arise from that. Once people are arguing, our local language says they are quarreling. Now, if you are arguing using facts. But if you are quarreling, you abuse. And that is where the difference is. If our people will understand that and find a word for appropriate word for argument as opposed to quarrel, then we can get to a place.
So an argument is healthy, but a quarrel
very, very, very healthy. Use facts. The quarrel, you just insult, you say things that are not be said, you abuse, vocal abuse, say anything. You know what I mean?
I do.
Yeah.
So, I have a few examples. But I want to ask the final question so that we can get into our next conversation on the show. Is free speech under threat, as we are being told by the NPP side of Parliament?
At the moment, how many examples of abuse of free speech can we cite? Let's say the current government, how many people are facing punishment or something for free speech? I don't know. Apart from Abronye that I've got now, I don't know whether there is any other person who is facing a trial for use of free speech. Okay. Now, for what I can see, for having the right, taking the action to put him before court, forget about what has happened in court. It is my opinion my considered opinion that it's the best way to test the limits of free speech, and I feel comfortable about that, because in the past people are arrested, ruffled, beaten up, and then they are released. They are never for free speech or perceived wrong free speech. But for the first time, the person who seems to have abused the freedom of speech is being put to court. Then the court will determine the parameters with which free speech can be exercised, and I think it's healthy to that extent.
Okay. I mean, I could go through a few examples, but we've quickly run out of time. So I'll give you the opportunity to make one last comment and your concluding remarks on this matter on the way forward.
On the way forward, I think that the judiciary is established to look into disputes and matters of this nature and come out with a clear definition or decision on what is right and what is wrong, what is doable and what is prohibited. It is only at the end of the trial that the public will know whether Abronya has gone beyond the limits or he was within the limits. And that is the reason why the matter is before the court.
And we'll wait for the outcome. We sincerely appreciate the time.
Unfortunately, the water is being muddied by the political commentaries, and it will appear as if unless the judge does something very drastic, the NPP will never accept whatever decision he arrives at, which is rather painful.
Your Lordship, thank you so much for the time you spent with us this morning. Justice Isaac Delali Duse is a retired appeals court judge, and he's been giving his insights into the current matter regarding the Minority Leader in Parliament, Honorable Afenyo Markin's remarks following the remand of the gentleman known popularly as Abronya DC into BNI custody, and the subsequent matters that have arisen since his comments with condemnations from government spokesperson and the GBA. So it's not the end of the conversation, and it's definitely not the end of the show, but we will take another break as soon as we wish His Lordship here a very pleasant day, and then we'll come back to get into some spice and sugar with Kojo Black and Valerie. So stay with us right after this, and we are back.